Hello, and welcome back. GovDoc News. No opinions, just facts and summaries of government documents. You take it from there. We are back again with the Supreme Court order from October 8th, 2025 in the case Ham v. Sockwell. Long one here. Long one, so buckle up. All right. We have an order from the Supreme Court denying a request for a stay in this case. So let's take a look at the case and see what we're dealing with. This is a federal habeas corpus case, meaning it is a case where someone is in custody and asks a court to review whether their detention is lawful or not. So, to the actual case. On March 10th, 1988, Isaiah Harris, a Montgomery County, Alabama deputy sheriff, was shot in the head while driving to work with no eyewitnesses viewing the crime. Prosecutors said it was a murder-for-hire plot where Sockwell, then 25 years old, and another man, Alex Hood, were accused of being hired by Louise Harris, Isaiah's wife, and her lover, Lorenzo McCarter, to kill Isaiah. The motive, according to prosecutors, was to cover up the affair and collect insurance money from Isaiah's policy. Sockwell and Hood were allegedly paid $100 each for the job, and Sockwell initially confessed on videotape, but later claimed the confession was coerced and that Hood was the actual triggerman. The original trial was in Montgomery County Circuit Court in 1990. Some important information about this original trial. Prosecutors used peremptory strikes, a way to dismiss potential jurors without explaining reasonings as to why, to remove several black people from the jury pool, raising questions about racial discrimination. The jury convicted Sockwell of capital murder and voted 7-5 for life in prison without parole. However, the trial judge overruled the jury and sentenced Sockwell to death, in a process that is now banned in Alabama since 2017, but obviously this took place before that ban. Also an important note is that court filings note that Sockwell has a low IQ, which his lawyers argue should disqualify him from the death penalty under U.S. Supreme Court rules set forth in 2002 in the case Atkins v. Virginia, basically banning executing people with intellectual disabilities. So, since his original trial and conviction, Sockwell has attempted to appeal multiple times. The Alabama Court of Criminal Appeals affirmed the conviction and death sentence in 1992. The Alabama Supreme Court also affirmed in 1995. The U.S. Supreme Court denied a petition for certiorari in 1995. And the U.S. District Court for the Middle District of Alabama denied relief in the case as recently as 2023. Then,
full video located on our channel.